Okay, we're going to be starting in just a second. As I sent a message out, I'm having some technical difficulties on my end from time to time, so I apologize in advance if there's a problem with that. What that may mean is my program may freeze at a certain point, which is a problem I've been experiencing today, which may cause me to have to reboot. So I may go out of communication for a moment or two, but trust that I'll be back within a few minutes to pick up wherever it is that we left off. We're going to jump in 1 second, start the presentation, but if somebody could just type a message to me to let me know that you can hear me. I don't have anything showing on my screen yet, so you wouldn't be seeing it, but I want to make sure that the vocals are good. All right, so then it looks like we're good to go. Just give me a second to get everything moving along here. Okay, so good evening. Welcome to everybody that is coming here tonight, and I thank you for coming. This is the Micklin Law Group's monthly webinar series. Tonight's webinar is Finding the Trust that Best Fits Your Needs. So without further ado, let's jump right into the materials. First, let me give you a little sense of what to expect in case this is the first time you're attending a webinar with me. I schedule the webinars to last about an hour. I do my best to stay within that time, and sometimes it's a little more, sometimes it's a little less. You'll probably notice by now this is a one-way communication, so you hopefully can hear me. I will not be able to hear you. But I will be taking questions at the end of this, which you can type into the box, I believe where either it says questions or chat. I think it's questions is usually the best place to put them. I usually recommend that you put them throughout the webinar, even though I won't be getting to them until the end, so that way you make sure to remember the questions you have and ensure that we get to them for you. I didn't attach. I thought I had. Oh, yeah, I'm sorry. I did attach. You'll see the bottom of your panel, which you should have on the right side of your screen, handout section, and I've uploaded the PowerPoint slideshow to there in case you're interested in downloading it. In many of my webinars, not necessarily this one so much, but in many of my other ones, there's often cases and statutes that are cited that some people like to have for themselves. I don't think there's a lot here with regard to that, but you still may be interested in the PowerPoint. And I will also, at some point in the near future, be posting this on the webinar archive page of our website at www.micklinlawgroup.com. So if you want to hear it again, it's going to be up there for replay. But I always encourage people to sit through the live presentation because it's a lot better for questions and answers. Next, I'll give you a little bit of information about me in case you either don't know me or haven't worked with me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been practicing law since 1996. I am a current member of the New Jersey and Pennsylvania State Bar Associations, licensed to practice both state and federal courts. I started my career as a law clerk to Judge Austin in Bergen County Special Civil Part. I then moved to Kessler & Associates, where I did complex commercial litigation for a few years. And then I opened my office, I think it was around 2000, in Nutley, where I currently am, a different office. And I was a general practice attorney at the time, but then I quickly concentrated my practice into divorce, family law, and estate planning issues, which is the focus of the Micklin Law Group. We now have a few associates that also handle those cases with us. My concentration is mostly the high conflict, high net worth issues and cases. Next is just a list of some awards or distinctions I've received over the past few years. I put these up here not as a way to boast, but I put it up so that those that are listening to me and those that are or may be working with me in the future will trust that I do have some sense of what I'm talking about, and I do my best to convey to people that I really care about my clients and the work that I do, but I'd like to make sure that people know that within that is a strong background and competent skills to handle these issues for you. Now let's quickly go over what we're going to cover. First, we'll cover living trusts. Now, a living trust is not necessarily any specific type of trust. It's more of a characterization, one of the main two characterizations, the second being a testamentary trust. Living trust is simply a trust that is created now and exists now or in the very near future, as opposed to a testamentary trust, which is referenced in somebody's will and only comes into being and only is created once that person passes. We will not be dealing with testamentary trusts because they really are the same or similar to the living trust information that we will discuss today, only they're created once the person who's creating it passes. Next, irrevocable life insurance trusts. These are a very specific type of trust, primarily similar in some ways to a testamentary trust, but has both characteristics of living and testamentary. It's a unique kind of hybrid. We're talking about children's trust, how to plan it, and what the purpose of them is. A lot of people sometimes think it's strange to have a trust for children that are currently alive, but there are many benefits to that kind of planning. We will also talk about charitable remainder trusts. These are complex trusts, usually for high net worth families or estate planning, so we may only touch a little bit on them, but it's good to know what they're about. There are a lot of benefits to that kind of trust planning, even for people of modest income with proper planning. Qualified personal residence trust, another complex trust planning, not as common as many of the others that we will talk about. It's for usually your primary residence, a way to estate plan to avoid capital gains taxes, estate taxes, and things like that. It's good to know, not as common as the others, but also very important to have some background on. Qualified terminal interest property trusts, commonly referred to as a QTIP trust. I'm going to give you a lot of information on this type of trust. It is a very common trust. It's very popular with either individuals that are divorced, that maybe have two sets of families. You may have blended families. You may also have spending concerns inside of the family that are all addressed. So it's a very popular, very common type of trust. Good to have some background on. And a Medicaid trust, a very unique, not as common as QTIP or the life insurance trusts, but very important and very significant to elderly couples or families that are trying to plan for both their care as well as estate concerns. So let's move first into living trusts. Again, these are a general characterization of a trust. Let's talk a little bit about some of the main benefits. Again, first, like I said at the onset, the living trust is something that is created now, so it sort of lives now, which is hence the term for living trust. There are significant benefits to creating a trust now. The first and the main is that it helps avoid the costs and delays of probate. Probate is the process in which a will, or somebody's estate, I should say, is handled when they pass. Whether there's a will or there isn't a will, the estate will go through probate. It's a very lengthy, very costly process. I normally tell clients you can expect about 10% of the value of the estate to be consumed by legal and expert fees, if not more. There are also often a lot of challenges and litigation that arise through the probate process that, albeit could be raised with trusts, less likely because trusts are not necessarily as public as a will becomes when the probate process begins. So while I've seen countless will contests and administration contests, and as a matter of fact, I'm in the middle of several of them even now, I've never seen a trust challenge, or at least one that's gone into litigation like a contest often will. Another benefit, it avoids dangers from jointly owned assets. Jointly owned asset, commonly like a house, for instance, depending on how the asset is titled or structured, will determine whether or not it passes to the other person or it passes through the estate. Different jurisdictions will have different presumptions about jointly held property and whether or not there's a presumption by the way it's named as opposed to the way it's not. Will differ from jurisdiction to jurisdiction. You may also have property in another jurisdiction than the one that you live in or the one that you die in, and that causes, aside from the different laws that apply, something called ancillary probate, which is a separate, additional, costly piece of probate litigation in the other state. So as I said, Cost of probate here can be about 10%. If you have to do ancillary probate, you're sort of doing two probate processes, and increases the cost significantly. Does not provide creditor protection. This is one of the two things that are most important to know about a living trust. That's a common misconception. The first is that it doesn't provide creditor protection. A lot of people think and try to transfer assets into a trust so that they don't have creditors attach it or liquidate it out from under them. A living trust, which is also called a revocable trust, does not provide that kind of protection. So it's often a misconception that people have. Another thing, and I don't think it's mentioned in the upcoming slides, so I'll just quickly touch on it. A living trust does not usually provide any estate tax or capital gain tax savings either. Many people do trust planning because they believe they're going to get significant estate or capital gain tax saving, which you do in many of the trusts that we will discuss, but not in a living trust. One of the good things about a living trust, unlike many of the others, is it can be changed or revoked during the lifetime with relative ease, meaning that the person, or person usually called a grantor, the person that creates it, is able to change it, modify it, take the property in and out of it, take it back for him or herself. There's a great flexibility that does not exist with many of the other trusts that we will see, which is predominantly the reason why you don't get the protections that we were just talking about, the creditor protection and the trust or the tax protection, because of the convenience and control that you retain with regard to your property. So it's a balancing depending on what your concern is for whether you do a living trust or not. In some states, a house transferred to living trust also loses homestead protection. This could be both creditor as well as tax issues. If you listen to this and you're not in New Jersey, for instance, Florida has significant homestead protections. I know New Jersey has certain tax advantages to it. If you are considering a living trust and you have homestead issues, you want to speak with either a lawyer or a tax or accountant for the proper advice before actually doing it. That goes along with the next issue that tenants by the entirety homes lose creditor protection when titled in a living trust. Tenants by the entirety is a type of joint ownership where you own the whole thing together with another person, but you are not a married couple. So it's a similar but different type of ownership. Transferring either partial or all of the ownership to that type of property in a living trust does lose a lot of creditor protection. Not going to go into a great deal of that because it's a little bit beyond the scope of just general trust knowledge, but if you are considering putting a residence in the trust, it's another issue that you certainly want to carefully consider. So next, we will talk about the Revocable Life Insurance Trusts, commonly referred to as ILITs. And we'll talk about some of the purposes and the benefits also to that type of trust. So first, let's look at some of the benefits. Creditor lawsuit protection. It's an irrevocable life insurance trust. So unlike the living trust we talked about, you do not have the ability to take your assets back out of the trust. The interesting thing to keep in mind is that may sound very challenging to people, but in many cases, you're not actually putting anything into a life insurance trust or an ILIT. It's just as it reads. It's a life insurance trust. It's created to take proceeds from a life insurance policy. So that doesn't really exist until the person dies, which may make it sound like a testamentary trust that I referred to in the beginning, but it's not, because you're creating it now, which makes it a living trust, but you're funding it with the insurance proceeds from someone's death, which makes it appear like a testamentary, but it isn't, because it's existing before the death. So the monies that go into there do have the creditor protection that you would not otherwise receive. It can be used to pay estate taxes. A lot of people actually take life insurance policies for that purpose. There's been changes in the federal and state estate tax laws over the last few years. Right now, to put it simply, New Jersey's estate tax law is very, very expensive for families in New Jersey. Life insurance is part of your taxable estate, which is also often one of the larger assets people have. But when people are aware that they may have an estate tax issue or even an inheritance tax issue to their estate, many will purchase life insurance for the purpose of paying that tax. But you put it into an ILIT for reasons we'll talk about more detail in a moment, because if it's not in the ILIT, it's an asset of your estate, which increases the taxes even more. So it's sort of a catch-22. You buy insurance to pay the taxes, but you increase the taxes by buying the insurance. Another significant benefit about an ILIT, and this also relates a lot to most of the trust planning, is that it makes funds immediately available to the heirs or the survivors. The probate process can take anywhere from 6 to 18 months. A lot of times assets are not available until largely through that or even at the completion of that. A life insurance trust, an ILIT, as well as many other trusts, possibly even most other trusts, have assets available immediately as soon as they're at least funded. And insurance proceeds and policies are usually funded and paid out pretty promptly. Like I said, as an aside, most trusts do provide that benefit unless there are specific restrictions in the trust, which we'll talk about a little bit later, I think, that restrict the beneficiary's ability to get it. But it's not the trust type that prevents it. It's the grantor's decision when creating the trust. A little more information you probably need on the issue, so I'm just going to kind of step past it now. It also avoids delay and expense of liquidating other assets. Again, the example I was giving you, when a person has an estate tax, they will buy life insurance to pay that, because otherwise you sometimes need to liquidate the asset in order to pay the tax. So let's say, for instance, you want to leave your house to your children, or to your nephew, let's say. So there would be an inheritance tax to that. That person, your nephew, would have to sell the house in order to come up with the money for the tax in many circumstances, which defeats the whole purpose of the plan. So providing the life insurance trust provides an asset that may be able to pay these expenses and allow you to really dispose of your property in the way that you want to and plan to. Life insurance policy is owned by a trust. The insurer pays the ILIT trustee. The estate is not the beneficiary. The purpose of understanding this is that the underlying purpose of an ILIT is to remove the assets as an estate asset, therefore not having to pay the estate tax or the capital gain taxes that could be, or not capital gain, the estate taxes or inheritance taxes that could be due on insurance policy are eliminated by putting it into an ILIT, because you no longer own the insurance policy. The ILIT owns it. It's owned by the trust. Some additional benefits: revocable life insurance trusts can be funded or unfunded, which means you can either put money into it now or not. Many people will put some money into it so that they can pay the proceeds. For instance, if it's unfunded, proceeds are being paid out of future payments by the policy owner. But if it's funded, the future premiums are paid by that money. So small amounts may be funded. You can also put actual real money in there. I've actually never seen it done, but you certainly could fund it with cash above the need for the premiums. But most commonly, it's going to be funded simply to ensure that there is money to pay the premiums. It's usually considered a gift, but it is also a way to transfer money outside of your estate. You can, like it says here, you can transfer a fully paid insurance policy into it. You're changing the ownership only, since there are no actual proceeds. You can transfer income producing assets so that the income is used for the future payment of the proceeds to keep the policy active. Also be monies that are used to pay some of the estate or inheritance tax issues for which you'd be creating this trust for in the first place. Either one allows the policies to be paid directly from the trust. That is the most common way to do it. I think it is advisable to do that, and I have to apologize for being uncertain as to the reason why. That's, again, something better reserved for an accountant to tell you. I think it relates to the ability of keeping the insurance proceeds non-taxable against the person who is donating it. There are some things with all trusts that you need to watch out for. You cannot pay the premiums directly. if you do so, it could lose the tax benefits and credit protection. And the reason is that it's not a properly created ILIT. The purpose of having it being funded is so that the proceeds or the policies being maintained and owned by the trust. It's not your property anymore, so you can't be the one paying for it. So you do need to have proper planning if this is going to be a significant part of your estate. Now let's look at some of the other benefits to the ILIT. There are many things that are protected by putting an ILIT together. And the cash value from the policy is protected if you have, say, for instance, a whole life policy that will have both a death benefit and an investment component. The investment component, which may also carry significant capital gains tax issues, is protected and exempt from or excluded from the estate. The death proceeds, which obviously the purpose of the life insurance is the proceeds, and distributions from the trust to the beneficiaries. Now, I'm not sure. I know that the income distributions, if there's income producing investments from the proceeds, they're distributed to the beneficiaries without tax consequence. I'm not sure if the corpus or the monies received from the insurance policies are similarly protected from income tax and distribution to the beneficiaries. Again, that's an issue you always want to verify with both your attorney and your accountant. Whenever we plan an ILIT, we will consult with an accountant to make sure that the proper tax concerns and consequences are being factored into it before moving forward. Another advantage, it can save often significant estate taxes. Like I said, a lot of time, life insurance are one of the largest assets that people have in their estate, and it can be significant amounts of proceeds, which can then cause a significant amount of estate tax, inheritance taxes. So by removing it, like I said before, you're making it so that it's not your property anymore. It's not included in your estate. So it will not have the normal tax consequences that it would otherwise have if it was paid directly as your life insurance policy. You also have more control of the distributions than the insurance than you own, possibly because normally you'll have one beneficiary to your policy, and when you pass, that's paid almost immediately to that person. If it goes instead to an ILIT, you can then put terms into the ILIT that determine how and when the money is going to be spent. There are different provisions called spendthrift trust, anti-alienation, discretionary distributions, and other protections. If you have concerns that either the person may have creditor problems, which could be not only credit cards and debts, but it could be a potential divorce or an ex-spouse. You may think concerned that they may have drug or addiction issues that cause their own inability to control their spending. You may just not think they have the capabilities of handling that much money, so you may want to have discretionary distributions or mandatory distributions, depending on how responsible you think they are. But you have control over that person's use of your life insurance proceeds, which you do not have if they're paid directly from an insurance policy and an insurance company. You can also put in protections if there's a competency issue or a potential incompetency issue. Competency and guardianship actions are very complex, costly, and very emotional processes for people to be engaged in, legal processes. You can build protections for an incompetent or incapacitated person into your trust language, just like you could a spendthrift trust or a creditor protection. And what you're doing is ensuring that their ability to use and misuse the money is safeguarded. Now let's talk about children's trusts. Something you don't hear much about, and I think primarily because it's not only usually most beneficial to a high asset affluent family, but also I think people are just not aware of it and just kind of refrain from things that are uncommon. First benefit of that is it reduces taxes. The main reason, aside from transferring valuable appreciative property and capital gains issues, children are taxed at a different income rate than adults, especially if you are in a high income family, possibly even a high income single family, the income generated from assets in a child's trust is taxed at a much lower rate than income produced by assets at an adult's. Also provides protection similar to the protections we talked about before. If there's going to be future issues as the child grows and becomes an adult, there could be creditor issues, there could be medical issues that the child's facing that causes significant cost to be incurred by or in the child's name or care. Like most trusts, it's not included in your taxable estate because you're taking the assets away from your ownership and you're making the trust the owner. So when you pass, it's not in your estate. As I mentioned, at the owner, it's a lower tax rate, which is significant. Now, there is one provision. I'm not going to go into great depth. Section 2503 says neither grantor nor children's creditors can claim trust assets while the trust is in effect and beneficiary under 21. That's only important to keep in mind if you're planning a long-term trust that's going to either be for a child who may turn 21 soon, or if you're doing like a long-term family type of trust where it's going to be in existence for a long time. You want to be familiar with those provisions specifically. A little more about children's trust. There are some disadvantages, as there is with everything. One is the disadvantage when the child's 21, they can often demand trust assets to be distributed immediately, which causes or can cause some problems not only with the child, but also in the trustee's relationship and the child's relationship, the trustee being the person that's handling the money. But some of the other problems, first, is the grantor, the person who's creating it, cannot withhold distributions from the trust. And extending the trust after the child becomes an adult may need the child's consent in writing. Because remember, when you're putting money into a child's trust, it's not necessarily, for lack of better words, death planning. Because you may be alive, you're transferring the assets into that person's name. It may be in effect for decades while you still remain in that child's life. And if you happen to be a relative to the child, and most commonly you're going to be, you're going to have the personal and family relationship issues also as part of these problems. So you need a lot of careful planning and a lot of forethought into what the future may hold before you can transfer assets comfortably into a children's trust. Next, we'll talk a little bit about charitable remainder trusts and the benefits of this kind of planning. Charitable remainder trusts, again, are usually for high asset families. Other favorable uses for people with more modest incomes and assets is if you have an asset that has a significant capital gain issue. A common example would be a person who inherits their parents' house, and their parent may have had owned the house from like 1920 and they bought it for $4,000 and today it's worth, $1.5 million. So in order to avoid paying issues or significant taxes is another reason why somebody without significant, and don't get me wrong, $1 million house is a significant asset probably to most of us. So it's not the common type of person that's going to do a charitable remainder trust. So let's just talk about some of the main protections. One, like we say with most trusts, except for the revocable living trusts, it is creditor protected. It can earn income during a lifetime, fixed income also, without significant tax issues. Most importantly, the reason why people do it is they get an immediate tax deduction for the what's considered like a charitable contribution, which is the incentive for creating a trust like this. There may be either, like I said, significant capital gains to an asset. You may have a significant income tax for some reason, and transferring assets into the trust and taking the deduction will offset the kind of burden. Now, there's also something called a charitable remainder annuity trust, which is a charitable remainder trust that provides an annuity type of income to the grantor. I'll only talk a little bit because, again, something this complex is a little bit beyond the kind of introductory theme of this presentation. But The advantages of the annuity trust is so that you can donate the similar types of assets for a charitable remainder trust and still receive some income or distributions in return. So you're not losing all the potential gains in income and benefits you would have received from it, but you're minimizing it and reducing the tax burden at the same time. Now that is different from the next one we're going to talk about, which is a qualified personal residence trust. This is, again, and I may have said this at the intro, it's a less common one because it's very complicated to structure, and you're sort of guessing. It's a little bit of a guesswork. What you're doing is you're transferring your residence into a trust, and you're retaining the right to live there for 10 years. And I think you may be able to increase that or decrease it, but then at the end, the residence passes to your beneficiaries. The purpose of doing that is instead of receiving the property, if you gifted it, for instance, you'd receive it at what it's valued today, whereas if it's transferred into the residence trust, it may be at the basis, which is what you bought it for, and may have been significantly earlier. For instance, the prior example I gave you of inheriting a parent's house with a significant capital gain, you transfer into a personal residence trust, and you're sort of passing that off to the beneficiaries that receive it. The problem becomes what happens afterwards, and it's difficult, and again, beyond the scope of this, whether or not you're going to have some kind of life estate interest to continue living in there, and if you're paying rent, do you pay to the trust? And it's just problematic, and a lot of people don't want to lose control of their home, especially people that have homes with high appreciation. Usually are people that have had their house for a very long time, so they tend to be elderly, and the mindset of an elderly person is not to give up their house and put it into a trust. It's old school mentalities don't really jive well with that kind of significant planning. But there are a lot of benefits to a personal residence trust. Again, it's always creditor and lawsuit protection. It's a nature of an irrevocable trust. Creditors only can go after your creditors can only go after you for your right to use the property and the rental value and the remaining terms, but not the property itself. That's the most important aspect. Is they can't attach the home. They can't seize or take the home because it's not owned by you, it's owned by your trust. However, like all trusts, there are disadvantages. If your beneficiaries, whether it be your children or your family, whomever, if they have creditors, they're going to receive the house free and clear to some extent, and their creditors may be able to attach the house. Now, there are ways to avoid that. The spendthrift provisions that we talked about before go to putting language in that says, for instance, the proceeds of the house or value of the house cannot be used or attached by creditors. It's a restriction that may provide the protection that you want. Something to consider when you're planning this, where you think your beneficiaries will be. Another disadvantage is at the end, they must distribute or convert the trust into some form of annuity, which means the house that you may have wanted to hold on to or to pass down may not actually be preserved in that manner. Now, let's move on to the qualified terminal interest property, QTIP. As I said, I think I said at the beginning, this is generally good for a second or subsequent marriage. There are a lot of benefits to this kind of plan. It's probably the most beneficial of all the types of trusts that we discussed tonight, I think, even with the ones that are upcoming. It ensures that your spouse will receive lifetime income from the trust. The spouse probably will not receive the corpus or the assets and monies transferred into the trust that you're passing, but will receive income from those trust assets for his or her lifetime. There may be a way to provide some trust corpus. When I say corpus, that means the assets that are transferred in to the trust initially, not the income that's generated from investments. There may be ways to put in provisions that allow some of the corpus to be distributed to your spouse after passing, but That can be problematic because the general purpose of a QTIP is to preserve the assets for either your children from either this marriage or, more importantly, a prior marriage. And the reason why a lot of people would do this, for instance, is if they're concerned that their new spouse may not want to provide for their children from another marriage once they pass. It's a way to ensure that that doesn't come up. You may have a stepchild relationship, but once the one spouse dies, that relationship may change, and this kind of protection is really intended for that kind of a situation. So once that happens, the trust principles pass to the. Once the second spouse dies, the children will receive the proceeds, unless again either that spouse, or unless it's changed or you choose a different beneficiary, or the other spouse may die prematurely, remarry, or other issues. Excuse me, it's got a sore in my throat. Moving on, like I said, the purpose is to preserve the assets. Most common purpose is to preserve assets from a prior marriage, because you don't know what's going to happen when you're not there to provide for them. Children would become the probable beneficiaries of the estate if you remarry and that spouse dies, but you can't ensure that. So this is a way to plan for that, to make sure that's done. And it can also be, don't make a mistake, it can be for the children of your own marriage too. There may be issues where one spouse is concerned that the other spouse may not provide properly for the children. There could be spending issues where you might need a spendthrift trust. Your spouse could possibly remarry, and now there's a new family. There could also be a remarriage and a divorce, and now you have a creditor. So a lot of things that could come up that a QTIP trust can really plan for and protect. Most families, most blended families, and anticipated consequences of blended families. So a little bit more now. Let's talk some of the benefits, which I already probably touched on a great deal, but let's go through some of the slides here. As I said, if you have a concern that your spouse may not be the most efficient with money, that your spouse may have a spending problem. They also may just not be sophisticated enough to handle their own money or large sums of money, for instance, from an insurance policy that may be more money than you generally used as a married couple, and you want to protect that person's ability to provide for them for the longer period so that their lives are provided for and it's not just spent and squandered. The income, again, is solely for the spouse's benefit, so there's no concern that any other children from a prior marriage, for instance, will have any claim to the income while the second spouse is still alive. And if you did it, there would be a problem with the unlimited marital deduction, which can cause estate tax concerns that married couples don't usually have until the second spouse dies. Not something that we'll go into deep here, but it's very significant when you're talking about estate taxes to have not only the marital deduction, but any kind of deduction, because New Jersey's estate tax is quite demanding. So the estate taxes are most often deferred until the second spouse dies. So while nobody ever really wants to pay a lot in taxes, there's usually less a concern for the children to pay an estate tax, for instance, than a surviving spouse, because the children theoretically will have more time to plan and earn their own living, where a surviving spouse may be kind of stuck in the position that they are without this kind of estate planning. So you want to minimize estate taxes to your spouse and sort of let the children fend for themselves, to put it bluntly. It won't protect assets against creditors because of testamentary trust, meaning the property that goes into the QTIP will likely be creditor protected if you have the right language. But because it is created in your will, it's a testamentary trust, the assets first go through probate. And if you have creditors or debts that are due from your estate, they will first be paid. Estate taxes, for instance, income taxes, they will be paid first before the QTIP is funded. There are, again, some additional benefits. It can shelter wealth for, and we may have briefly talked about this, a spendthrift spouse, a spouse that may have spending issues, a spouse that may have future financial legal difficulties, like I said, a remarriage and divorce, financial problems, medical injuries, lawsuits, things like that. Um, and it can shelter if that spouse does want to preserve the assets to pass to his or her children, even if it's stepchildren, even if it's the first spouse's other family, their surviving spouse still may want to provide for those children. And this is a vehicle that will allow them. One thing to remember, though, um, the trust will only be safe from your spouse's creditors, but not the income that's generated from it. So let's say you put, I'm making up numbers, $3 million into a QTIP trust, and it generates $100,000 of income each year. That $100,000 of income goes into your spouse's hands. And if there's a creditor, that creditor will be able to attach that income. And the income must be distributed as earned. A QTIP trust cannot retain the income and add it to the principal or the corpus. It must be distributed. It's a mandatory distribution. And that is less of a concern because your principal or your corpus is still being protected. But if your purpose of the trust is to provide a stream of income to your spouse, and that stream of income is attached, then it hasn't really accomplished the purpose for which you set out. There are more. I think I said when we sat down that there would be a lot more interest and information about a QTIP because they are so very common and provide for so many family interests as well as creditor and other trust interests. So, but I'm going to kind of lump them all into one quick slide so that we don't spend all night on a QTIP. This is an irrevocable trust, so you can use this kind of planning to maximize your marital deduction. The purpose is to shift assets from a higher risking spouse to a lower risk. Usually, we all sort of assume men are going to die first. So depending on how your assets are titled and also considering what kind of capital gains taxes you may incur, this allows you to shift assets. Even though you do normally have the unlimited marital deduction, you want to plan for when it goes to your children to maximize taxes. It is subject to fraudulent transfer claims. Fraudulent transfer claim is when a creditor comes to court or sues a person, says, this person I'm suing had assets and they purposely transferred it to somebody else because they knew I was coming after it. If under the law of fraudulent conveyances, if it's deemed to have been done for that reason, it can be undone or reversed, which not only frustrates the entire purpose of the trust, but also increases a significant cost to the family and eats away at the assets that you sought to protect. So a spouse who makes this kind of transfer must understand that the transferred assets could be lost by either, like I said before, a future lawsuit, a future divorce, spending problems, drug addiction issues, future problems with the children that may also pour over into the family. It's just very difficult to know, with any situation, what's going to happen long term. So you plan for what you can reasonably foresee, and you just hope for the best. I always urge people to use as much specific language in trusts so that these issues are addressed. A lot of people draft trusts customarily with very broad general language, and I don't think that that's really effective in today's society and the legal climate that we have. But I go adrift. So let's talk about Medicaid trust. I believe this may be our last trust. Now, a Medicaid trust, not to be confused with a special needs trust or a supplemental needs trust, which, given time, I'll talk a little bit. Actually, I'll take a minute now to talk about those because we won't talk. They're common trusts, but they're very, very specific, unique trusts. A special needs trust, also referred to as a supplemental needs trust, so they're one and the same, is a trust that's intended to leave assets to an individual who is receiving governmental benefits so that they do not receive or they do not lose the governmental benefits. Let's say you're getting Medicaid or food stamps or whatever it may be, and you are likely to come into an inheritance, or you have a lawsuit, or you have a wealthy family member wants to give money to you. If you receive this money and it generates income, you have assets and income, you may lose the benefits that you're receiving. So you can put it into a special needs trust so that it's not considered income or assets if it's properly managed, and you retain your benefits. The important thing to know about the special needs or supplemental trust is that it cannot be used for necessities. I'm going to say food, clothing, shelter, but it's not really that simple any longer. But it can't be used for anything that the governmental benefits are being used to pay for without either jeopardizing the benefits or reducing them. So enough about that. That's not going to really be part of that because it's a unique type of irrevocable trust. That's probably do a whole webinar on that just alone, which I may do in the future now I think about it. So a Medicaid cost is typically for a person that is in or receiving sort of 24-hour care in nursing home and has extraordinary or exorbitant costs. The purpose of it is to shelter assets so that you qualify for Medicaid so that your assets don't need to be exhausted to pay for these exorbitant costs. The grantor or the person that's creating this transfers their assets to another. This is an irrevocable trust. There is a main difference, and one of the main benefits to starting this kind of trust as opposed to some of the other ones we talked about, even to the special needs, if anybody's familiar with that, is in this kind, the grantor can receive some of the income that's generated. They can still receive the benefit of their assets and the income generated, which is uncommon for an irrevocable trust in order to keep their protection. And your children or your spouse can be residual beneficiaries. You may have a child that's in the need of a Medicaid trust. It could be your spouse. You can still use this to provide for beneficiaries upon the second person's passing, the beneficiary's passing. Grantor can receive to the amount of maximum allowed by Medicaid. I'm not going to go into the specifics again because you have to be an asset-free grantor to qualify for Medicaid nursing home assistance. So by doing this, you may be the individual who needs the Medicaid. You may be able to transfer assets out of your control for that purpose and still qualify. Now, with all trusts, as I keep saying over and over again, there are some disadvantages. Advantages. The advantage, it is asset protection like the other irrevocable trusts. So the trade-off is giving up your assets but not losing them to a creditor. You are prohibited from using trust assets other than for healthcare purposes. So that's a little ambiguous. I think as our society ages and lifestyles change, what is considered healthcare purposes may be a very broad definition, similar to a special needs trust. I know I keep going back to a topic we're not going to talk about, but additions to a house, possibly some kind of therapeutic vacations. You might be able to have a much broader use of the funds for the person while still receiving Medicaid to pay for the nursing home and costs. You may be able to get them additional assistance in the nursing home because, in my experience, the care in a lot of nursing homes is not necessarily always up to par. Again, it limits the income by the limits set by Medicaid. Important to know, not something that we're going to go into in deep here. There is another disadvantage, which is the 5-year look-back period. This is sort of related to the fraudulent conveyance aspect, and they can look for transfers up to 5 years in the past to see whether or not they were transferred for the purpose of avoiding creditors or avoiding or obtaining the Medicaid issues, or if there are maybe medical creditors, for instance. So, the disadvantage here is that it's sometimes difficult to plan long-term because this 5-year window is a significant period of time and a lot of issues develop inside of that window. That may be the last slide. So let me take a few minutes, see if we have any questions. And I hope that there haven't been any technical issues. I haven't seen any. Okay, I have a question here. I'm going to read the question now, obviously not the person who listed it. Can a personal residence trust be set up with a life estate for the owner so they live there as long as they would live for a specific number of years? Well, yes. I mean, that's sort of the purpose of it. But it's a complicated calculation to figure out the length of time. But yes, the purpose is to, and I might be misunderstanding the question because it says a life lease for the owner. I think that's probably life estate. Um, but yes, the problem really is if the person lives longer than the years contemplated. Any other questions? I'll give it another moment or two before we move into. There are some poll questions. Get a little feel for the people watching the webinars tonight, so we can better serve and plan future ones. I'll wait another minute or so just to make sure there's no other questions. I don't see any up here. Okay, so I'm going to launch a poll real quick. Your answers are not public. I may or may not post the results of the post, but not anybody's names. And my understanding is that you cannot see one another, so your attendance here and at future ones is also considered confidential. So give me 1 second. And just polls. Here we go. All right. Just take a second quickly, fill the answer just to get a sense, so I can learn where people are coming from and know better how to attract other people to spread this information. And what I didn't mention in the beginning, I'll quickly just mention as we're doing the polls. The purpose of doing these webinars each month is that I learned a long time ago that there's so much information to give to a person that it's just impossible to do it like when I normally have a consultation with people or even client meetings and questions. Giving out the information is impossible. I can generally sit for days on any one topic. So I started doing these as a way to not only give people information, but to then place it on my website so that I tell clients all the time and consultants, go to my website. You can listen to something for an hour. You can listen to 10 different webinars for free. You don't have to pay for anybody's time. And you get this information. It's a much better way to educate everybody on these very, very complex, difficult, and sometimes challenging situations. So we're moving right along. I'm talking as I'm putting the polls up. That's good to know. This is a good time. Let's see what more we got. Got just a couple more real quick. Good. Everybody's answered quickly. Everybody probably wants to go home fast. Two more questions. And I think we have just one more. Now this also goes if there are clients that may be attending also, if there's questions that didn't get addressed. All right, so that closes our poll. If, again, as I said before, this will be listed on my webinar archive page at www.micklinlawgroup.com. Usually takes us a couple weeks to get it out there, but I do invite you to go now, not only to see on the webinar archive page some of the older other webinars we have, but the webinar page itself will tell you the upcoming webinars and give you a link if you wanted to register for them. So I thank you for attending. I hope you found this helpful and informative. If you have questions that were not answered, you should have my email from your registration. Just send me a question. Let me know how I can help you. With that, I'm going to wish you all a good night and hopefully see you at our next webinar next month. Good night.